On its last working day, that is the 20th of December, the Constitutional Court released a record 7 judgments. It's the highest number of judgments released on a single day in the court's history. Let's unpack some of these now, and we are joined to help us do that is Mbekezeli Benjamin, legal researcher and advocacy officer at Judges Matter. Very good evening to you, Mbekezeli. Thanks very much for your time. I want to start with the one involving the city of Cape Town, which is about providing temporary accommodation to people facing eviction in the inner city.
Good evening, Vuyo, and good evening to the viewers. I hope you had a pleasant Christmas. Yes, so the case is called Chanel Commando versus the city of Cape Town. It really involves the issue of gentrification. We all know that in cities like Cape Town, there are some areas where working class families used to live, and over time, those areas, more people have moved in, and so property developers have gentrified the area, so have bought up some of those houses and converted them into maybe luxury apartments. So this case was about a group of families from Bromwell Street in Woodstock, and they had lived in rented houses in Woodstock for several generations. And so a property developer called Woodstock Hub came in and bought some of those properties with the purpose of leasing them out as apartments. And now that meant that the families who were living in those apartments were evicted from those apartments. And now the Constitution requires that municipalities like the city of Cape Town provide alternative accommodation, temporary emergency accommodation, to families that are being evicted and that might face homelessness. And so the applicants in this case were a group of those. But what the city of Cape Town did was to say, look, we do not provide temporary emergency accommodation in the inner city. We can provide it, but it will be about 40 or so kilometers away. And so the applicant said, look, we've lived in the inner city for several generations now. If you're moving us away, it will have other implications on us beyond just the accommodation issue. And so they took the city to court, insisting that they get provided with alternative accommodation within the inner city, in Woodstock and surrounding areas. The High Court agreed with them initially. The Supreme Court of Appeal rejected the High Court's finding and in fact ruled in favor of the city of Cape Town to say there is no obligation on them to provide accommodation in the inner city. When it came to the Constitutional Court actually agreed with the applicants and rejected the finding by the SCA. The court said the municipality, the city of Cape Town, does have a constitutional obligation to provide temporary emergency accommodation, and that accommodation may be provided in the inner city in deserving circumstances such as this one. Yeah. And so what the case did is, in fact, emphasize principles that already have been in place for some years, but now there's an additional burden that says municipalities like the city of Cape Town must provide a temporary accommodation as close as possible to where people were evicted from.
Of course, I mean, the case that has taken many, many years to conclude, and as you say, whatever accommodation these municipalities must provide must not be too far from where the people originally lived. There's another one, Ingwana Mhlaba versus the Minister of ConCourt, which in this instance speaks to rural communities. In other words, the ability of traditional leaders to raise money by imposing some form of tax. Of course, also what communities can actually take us through that one very briefly.
Yes, so briefly, this case involves a practice where traditional authorities were basically forcing people to pay a levy or tax to the traditional authority for services that they need. So, for example, if you need to bury a loved one or for the chief to authorize that burial, you needed to pay an amount of money to the traditional authority. If you needed a letter to prove your proof of residence, you also had to pay a certain amount to the traditional council. So what happened was in Limpopo, the provincial legislature passed a law called the Limpopo Traditional Leadership and Institutions Act. And as part of that legislation, there was a section, Section 25, that said that the traditional authorities do have a right to impose that levy, or that they call it a traditional council rate. And if you don't pay that levy, then there will be consequences for that. And that issue was taken up by some of these communities in Limpopo. They challenged the constitutionality of that provision because essentially it allowed the traditional council working with the premier to impose a tax on the residents of Limpopo. And so they said it's unconstitutional because only a legislature in the form of parliament, a provincial legislature, or a municipal council may be able to impose a tax. And so they took that to the High Court in Limpopo initially, and it ended up at the Constitutional Court. And the Constitutional Court agreed with the residents to say it is unconstitutional for the premier and traditional councils to impose a tax of this nature. It's not open to them. They don't have the constitutional powers to do so. And so they should immediately stop. Now, the importance of this is that it has, yes, implications in Limpopo, but also in other communities like the Eastern Cape and KZN, where there are similar legislation that are in place that deal with these kinds of taxes. And I should also add here, Vuyo, is that pre-colonial times, there used to be these kinds of, they call them tributes, where people bazoya komkhulu to give an amount of money or cattle or anything that they've grown as a form of sustaining the traditional authority. But the problem was that it was now imposed, and which is what the Constitutional Court said was wrong.
So rural communities spared. Here's one that is of interest to me because of my age. It concerns the dismissal of employees who have reached retirement age and whether this constitutes age discrimination.
Yeah, so this is an interesting one because the facts of this case essentially are that there were a group of employees. Some of them were working for the state, including State Information Technology Agency, and some of them had reached retirement age, but they had been brought back into the companies that they worked in order for them to continue working on a contractual basis. Now, some of these employees were dismissed because they had even went further than the retirement age, and some of their contracts had elapsed. But now they alleged that the dismissals were unfair, and they were automatically unfair in terms of the Labor Relations Act because they were based on age. That was the only consideration. And what the Labor Relations Act, and according also to the Constitution in Section 9, says you may not be discriminated on a group of grounds, including age being one of them. And so they said these companies were essentially discriminating against them, and that constituted an automatically unfair dismissal. And when you can prove an automatically unfair dismissal, you are entitled to 24 months of compensation. So they were claiming that amount of compensation. Now, this case in the Constitutional Court was really complex because there were several judgments. None of them sort of agreed on the interpretation on whether, in fact, this constitutes age discrimination. And so that question is sort of left hanging in the air. As a broad principle, but they did look at the specific cases because there were a number of applicants, and they said in some of the cases, yes, it does show that the dismissals were motivated by considerations of these people's ages, and that was automatically unfair, and so they should be entitled to the compensation of 24 months of their salary. But the court really hasn't concluded on whether this would apply necessarily in other cases. And so the question is really left open. And that's also part of the reason why this case in particular took about 3 years to process, because the judges themselves could not agree on a specific interpretation.
Well, thank you very much for that. It's all I wish. I wanted to go to a couple of others, but unfortunately we've run out of time. Thank you very much for your time, Mbekezeli. Benjamin, on that record 7 cases that the Constitutional Court on the 20th of December issued the highest number released on a single day in the court's history. More news when we return. Don't go away.